Welcome everybody and good morning to the next webinar in our business webinar program, Options Facing Liquidation or Insolvency. We're really pleased to have some brilliant speakers with us this morning. And if Umang and Joe could turn on their cameras, that would be lovely, please. Right, a quick sort of intro. It's incredibly hard to get your finances back on track when your debts are piling up and you've got creditors at the door. Hundreds of thousands of people are struggling with debt problems, but the HM Treasury has now launched a new debt respite scheme, which Joe will be talking about in more detail. The facts and figures: around 700,000 people struggling with problem debt, and they'll benefit from this breathing space, which again Joe will come on to talk about. Just briefly, the scheme will give those facing financial difficulties 60 days to get their finances back on track without the debts piling up, without worrying letters or enforcement actions. And people will also have access to professional debt advice with stronger protections for people in mental health crisis treatment. I'm going to leave it there, I think, because I'm not the expert on this. Umang and Joseph are. So first up is Joseph Sullivan. Are you known as Joe? I think you are. Joe works for the Insolvency Service and is the official receiver for London and Southend. Joe, over to you.
Thank you, Sally. Good morning, everybody. Very grateful to be here. Really good to be able to talk to you all. Grateful for the invite. Thanks for that introduction, Sally. I've got some slides that I'll run through with you just to sort of talk about what we do in the Insolvency Service when it comes to sort of insolvency and liquidations, and where we sit in that process. And it's really good to have an insolvency practitioner with us today as well, because you'll hopefully be able to see the difference in terms of what happens when somebody goes to see an insolvency practitioner versus what happens when somebody has an interaction with the Insolvency Service. So I'm just going to share my screen. So I'm just going to go to my from the beginning. Right. So just an introduction to begin with. So we'll start with liquidation. So as an official receiver for the Insolvency Service, we're responsible for compulsory liquidation. So that is where there has been action taken against the company, and that goes through the court, and then a winding up order is made, and then that will come to us to deal with. Now, the numbers of those at the moment, as I'll come on to in a little while, aren't what they used to be due to the pandemic, but we've still got plenty of cases coming through our door. Usually what would happen then is the company has essentially exhausted all options, and creditors have felt the need to take that enforcement action through the court to wind the company up. When we get the winding up order, as liquidator, we've got quite a few roles really, and I've sort of briefly summarised the main ones there on the screen. So we are there to deal with assets for the benefit of creditors, and we're also there to carry out investigations into the company, both in terms of what went wrong, why the company went into liquidation, but sort of also to investigate the conduct of directors and how they've managed the company. And that can take some time. We still have very much a need for insolvency practitioners. When it comes to there are assets that need specialist assistance from an insolvency practitioner, and we will take steps to nominate an insolvency practitioner in our place. So we have a rota. So each official receiver has a rota, and insolvency practitioners will be on that rota local to our official receiver offices, and we'll get their consent to have them appointed in our place, and then they can go and take steps to realise the assets for creditors' benefit. Creditors can also request an insolvency practitioner put in place of the official receiver. Where there's a bit more of an interesting case, and there's complex matters involved, or we've needed to take steps to put a provisional liquidator in place because there are concerns around how the company's operating, then those liquidations will be dealt with by our public interest unit. Again, there's an official receiver responsible for that area. So very quickly about how we do our work. So this is Official Receiver Services that's responsible for dealing with compulsory liquidations, but also bankruptcies as well. And we launched a new operating model in October. And this is all about streamlining our processes and making our work more efficient, more flexible. And if you have any dealings with us, or you've had dealings with us, what you'll notice that you'll be dealing with different people throughout the life of the case. And that gives us added flexibility, particularly in respect of sort of case numbers in demand, which I'll come on to at the moment. And we've got centralised teams now dealing with core functions. So we've got teams dealing with properties, we've got teams dealing with, in bankruptcy, income payments agreements, and we've got teams dealing with sort of the asset side of things as well. So that kind of sort of gives you an idea of how we go about our work. We've spent some time over the last 6 months or so embedding that process in, and we're going to continue to do that and over the next few months. A few stats for you very quickly. So during Q1 of this year, that's how many total company insolvencies there were in the UK, and there's a breakdown of the different types. As you can see, they're compulsory liquidations, sort of quite low, and perhaps more interest to insolvency practitioners. CVLs still showing quite a few numbers there, and then just broken down for the month, 925 company insolvencies. So on the trends, so in 2020, they were at the lowest level since 1989. And if you look at what was happening prior to the COVID-19 pandemic, there was a slightly increasing trend since 2017, but this was primarily driven by CVLs. But on a decade-to-decade basis, company insolvency still remained low. In terms of the pandemic itself, they've remained low since the start of the first lockdown, and we think this is really been driven by the government measures being put in to support businesses and individuals during the pandemic. And I'll come on to some of those points towards the end, just to cover off what Sally was saying in her introduction. So really, I thought it would be beneficial just to set out what's going on at the moment and giving you sort of a bit of a flavour of sort of what's happening really. So very recently, and this may be of interest, I don't know if I'm able to share these slides around to everybody on the webinar, but there's guidance for the official receivers, which has been recently published. Now, this is our operational guidance, which really sets out everything that we do in relation to our work from start to finish on both company liquidations and bankruptcy, whether it be to deal with assets, whether it to be arranging some insurance. All of our work is set out, and it's quite user friendly, it's quite easy to follow, and you may find that useful in finding out a bit more information about what we do and how we do it. A big part of the impact of case numbers is the Corporate Insolvency and Governance Act 2020. So this is all about providing businesses with flexibility, breathing space during the COVID-19 outbreak. There was sort of restrictions within that, so that led to a temporary suspension of winding up petitions and statutory demands, and what that's meant really is we've not seen that many cases come through to compulsory liquidation, and those measures were extended until the end of June. So we're still in a period of protection, if you like, from some of the things that otherwise would have happened in relation to insolvency and liquidation. And really it's difficult to predict what might happen from the end of June onwards, because are we going to see an influx all of a sudden, or is there going to be a bit of a lead in? There might still be a negotiation phase that actually are certain companies going to sort of pull the rug and think, well, actually I've exhausted all options now. But it's also factoring in some of the end of some of the support schemes. So we've got furlough, for example, we've got bounce back loans, that's all really important. And Sally mentioned breathing space as well. So that's for individuals, and Insolvency Services are a partner in that with HM Treasury. And we're really interested to see what effect that is going to have and what impact as we give that support to individuals that really are in that space where they need that 60-day protection before they get to a stage where actually they need to take any further action in respect of their debts. In terms of directors specifically, I think part of my initial brief, if you like, was around sort of what support is there for directors, because that's sort of slightly different to what's there in respect of your personal debts. What Insolvency Service is focusing on really is sort of a commitment to develop a programme of director education. So we've got lots of experience in relation to how we've investigated director misconduct in the past, and obviously the effect that that's had on creditors. So we're going to be sharing that and developing a package to tackle cases where sort of misconduct's already occurred, so we can help that prevent that from happening again. But in terms of sort of advice, that's not really something that the Insolvency Service specialises in, is equipped to do. That's more for a specialist insolvency practitioner in terms of advising directors of what the options are available for their company, and perhaps for themselves as an individual if they're exposed to guarantees, for example, and then there's a personal impact, and we might hear a little bit more of that in a little while. Continued support that the government is able to give for those companies, for those individuals in that situation. And then a couple of other things that I think are worth mentioning. So it's perhaps not overly relevant to this topic, but certainly is sort of relevant to the wider creditor community, I think. And that's sort of pre-pack administrations. And for those of you that don't know, that's where an insolvency practitioner has sort of agreed a sale to a third party prior to his or her appointment as administrator, and then effects the sale immediately or very shortly after the appointment. And there's been concerns for some time that actually that process is not very transparent. The sales often happen to connected parties, but there's going to be some more independent scrutiny around that, where the sale is to a connected party, and that's now coming to force. And the Insolvency Service has now acquired powers to investigate directors of dissolved companies. So, where a company has been dissolved, it's not subject to formal insolvency. There's limited powers to investigate what the director's done. Have assets been put out of reach of creditors? Now there's going to be new powers for the Insolvency Service to be able to look at that. So hopefully that was a sort of a helpful summary. I've got my details there on the screen if anyone wants to contact me sort of directly and get in touch. And I think we've got some Q&A at the end as well, so I'll be happy to take any questions there.
Lovely, thank you very much indeed, Joe. Thank you for that sort of whistle-stop tour. When we do come to the Q&A, I would like to learn more about the breathing space programme, because that, I think, sounds, I can't imagine anything being more stressful than your company going to the wall. And there's been much talk, obviously, at the moment with lockdown and mental health problems and what have you. But that leads in quite nicely with Joe's presentation to Umang Patel. I'm really pleased that Oasis Accountants introduced us to you. And I then learned something that an accountant isn't able to talk about these matters. It has to be an insolvency practitioner, which I hadn't realised. So I'm really pleased that you're with us, Umang. Umang runs Noom Insolvency and is licensed as an insolvency practitioner in the UK by the Institute of Chartered Accountants England and Wales. Umang, over to you.
Hi, good morning, everyone. Very pleased and thank you to giving me this opportunity to speak at least few words about in a current market right now, there is immense issues that all the businesses has been experienced right now, and they are the government has done their bit by providing as much support as possible and last year. And there was a lot of new, Joe has already mentioned that Corporate and Insolvency Governance Act came into place, where you cannot able to enforce those enforcement action either by landlord or by creditors. But unfortunately, they have very limited time. They have already extended twice, and it was initially was just for 3 months, but he just mentioned that it will be finished by 30th of June. So all the businesses have to keep this date, which is very, very important. One is this enforcement action can be taken by anyone from 1st of July onwards. And the second thing is that the furlough scheme will be also be finished in a very small time. So now, from last 1.5 years, Joseph has mentioned that the insolvency have gone really, really outnumbers. The reason for those things is that because of the government intervention, the insolvency, when the COVID was hit, all the businesses were instructed to close. That means that but the fixed cost on these businesses was continued, and they need to be paid. So the government has grant a loan, as well as the council has helped them by giving the grants, but that was not sufficient. When the businesses have been recently been opened, they were already experienced with huge amount of debt in question. And right now, when the turnover was not sufficient to cover those costs, and the costs need to be paid, the businesses will be in a very difficult stage to consider what are the options will be available. And in this place, you need to consult insolvency practitioners or any business advisor who can give you a helping hand and the options what you really needed. Now I can go more in more technicality about the issues, about what nowadays the business will find. But in very simple words, when our insolvency practitioners is the how about the businesses can be survived, okay, and they can back to when they were drowning underneath, then they can just put them back to the success rate. So those are the very focus area where the insolvency practitioners come in place. There are number of insolvency, those people who are not aware of that there is either it can be corporate insolvency or it can be personal insolvency. So this is the key difference between both insolvency, that people always make a wrong terminology. So and then the meaning will be quite different. But those something that you don't need to understand the technicality, something that insolvency practitioners always guide you hand to hand, that what you need to do, how you need to do, what are the issues, that advice that you get it from the insolvency practitioners will help you to overcome from this technicality difference. The key factor is that once the insolvency has been been found, that to the knowledge of the director have a fiduciary duty to take actions on the benefit of the creditors. Now the key creditors can be suppliers, HMRC, business rates, it can be anyone. So the duty they owe to all of them except their personal duty. So the personal interest will always be considered, will be lower compared to the duty they owe to creditors. So over there, you need to ask a lot of questions to the insolvency practitioner, that this is the situation, what sort of action or options will be available for me, and how I can overcome from the current issues. A lot of people have sleepless nights and everything. They are really worried. The employees are worried about their jobs. The business people are worried about, how I can come out from this like ongoing debt, the mountains of debt, I would say. And but there are, the good thing about that, there are provisions in Insolvency Act that, if the insolvency is genuine and insolvency is not your fault, then you can be, come out as less harmful way as possible, and you can continue your business or, opportunity, whatever you have going forward. So there is, but there are lots of risk involved as well, which you need to consider, because there are lots of powers were given to the insolvency practitioners, when the liquidation or when your company is subject to any insolvency process happen. You have to, there are minefield has been done that, at the, like, when the insolvency, when you agree to insolvency, you always, we found, from last 10 years of experience, that the directors wanted to give as least as possible, and the insolvency practitioners, for the benefit of creditors, they wanted to take as much as possible. So we have to find a right balance, and how and what it can be allowable within the degree of law. Now this the technicality issue that you can directly discuss and consult the insolvency practitioners. They will be the right people who can guide you. But another thing is that a lot of businesses have taken bounce back loan. Now the what people and the director has misunderstood, that this is like a grant, and they have taken, and it is subject to abuse as well. And what we have found, that a lot of people took the loan when the business was insolvent, and then they have used it for a different personal purposes. Now those purposes, if that's not the commercial, then mind it, you have to be ready for the consequences, because what we have found out, that that the government has given those contracts to KPMG. They are also giving the guidance to the insolvency practitioners, that about how you have to, when the bounce back loan is outstanding, you have to report the directors to the HMRC, to disqualification team. There are a lot of issues will be there, so that all the businesses, when they have taken the bounce back loan, and some of them have used for personal purpose, though that's are not allowable. Those, this is simply for the purpose for the commercial only. And then I would just highlight that commercial means purely commercial. If anything goes straight not in the line, then those are subject to risk. And it can be happen that the directors could be disqualified, could be subject to recovery if in case of an insolvency. So the early advice on those loans would be very, very much handy, and they have to be very careful, to progress, in the current market. Now, it also happened that, that you will be subject to, if you have a big debt and your debtors might subject to insolvency, then you will be forced to insolvency as well. So it is not always that that insolvency comes, just because your mismanagement. Sometimes it is outside factors also. Like right now, it happens because of COVID. A lot of businesses need to be closed, and when they started, it takes how long it's going to take, we don't know. And back to running before the COVID era. So those are the lot of things that they have to understand. And when the business people would not understand, they need to take a guidance from the insolvency practitioners, their accountants, their solicitors, about what steps they need to take, so that they will not be criticized personally, or sometimes it also, we have seen that the directors have to contribute personally for the losses suffered by the creditors. So those are, it is quite dangerous sometimes for a lot of people, that what action they need to take, before it's too late. We cannot leave the situation longer than is necessary, but at the same time, they have a responsibility to creditors, and that's the key thing right now. The from the now what we have started to see, that HMRC haven't issued any petition from last 1.5 years. They haven't even chased it to a lot of business creditors because of the COVID and everything. But now they have to start from somewhere, about their enforcement action will start to chase their debts and everything. So the any business owners will have to consider that one is bounce back loan payments will be start. Second, if you haven't paid any rent, the landlord can start from 1st of July onwards their enforcement action. And the third thing is that if they have not, even the business rates and everyone have started to open, so a lot of businesses, when they start open, they will get all this cost straight away onto pay. So they have to tackle a lot of things at the same time, and all the business owners should consider all these issues, that whether they are, they have sufficient capital to continue or not, or they need any more help. Then obviously you can seek some help. There are a lot of institutions out there as well to help, to give helping hand. And if you feel that the burden on you is far too much, then obviously you should definitely at least consider to discuss with your accountants, your solicitors, or insolvency practitioners directly as well. We get huge amount of calls and directly. We do for initial free of charge as well, to give whoever comes to businesses, then we can at least give them initial consultation free. So you can come to us and at least provide us your case, and then we have seen and guide a lot of business owners that they don't have to go into insolvency as well. So we always try, the insolvency practitioners have to try as much as possible, but when they see that the continuation will make more worse for the creditors, then they have to take steps in consultation with the director, how to take it forward. Now, Joseph has mentioned about the compulsory liquidation. Those are the court action, where it is happened through the court, when any creditors have made an petition against the businesses. Now, there are also out of court provision is there to put the company into insolvency, and those insolvency is made out of court, where the insolvency practitioners can help you to take it. Those steps is quite quick, and also you get insolvency practitioners to deal with them from the very initial onwards. They can guide you, they can take it, the insolvency, hand to hand until the whole insolvency is finished. But beware that after the appointment, the insolvency practitioners has to change their cap. So before they were capped with the advisory role to the director, but afterwards their cap will be changed to the creditors. So, and the duty for the insolvency practitioners is to realize as much as assets as possible for the creditors. So just contact us if you have any other question. Happy to help. Over to you, Sally.
Thank you very much indeed for that, Umang. As I always say about these webinars, I learn such an awful lot myself. Alan, do you want to, I'm sure you have some questions. Do you want to, and then we've got a few questions in the Q&A and chat as well. So Alan, over to you.
Thank you very much, Sally. And
Umang, could you just stop sharing the screen, Umang?
Oh yeah, sure. Just 1 second.
No worries, thank you.
So yeah, thank you, Joseph, and thank you, Umang. Our chairman went through a very tough time not so many years ago. And Chris, I would welcome you to put any questions in the Q&A box. You've put a comment in the chat. Let me tell you one whose company went into CVL. It's utterly devastating. Are there any questions you'd like to ask that would be a good advice or good questions for our presenters? One of the questions I'd like to ask, though, is if you know your company is heading into choppy water, let's say, and you potentially have the issue coming up, when is the best time to ring the alarm bells and go along and get some advice, not from your accountant, but from a liquidity entity, either Joseph or Umang? When would you advise people to go along and ask?
Like, I would say that when the insolvency bells start ringing, that when you cannot able to see that in you, the director, or they feel that they are in some sort of difficulties to pay the creditors when the debt is due. At that point, you have to start exploring your options, that what can be done. Now, the earlier you come, the better opportunity you have to revive the business, or sometimes through rescue procedure as well. But if you come at the very late end of the stage, then you won't able to have that much options to make it continue the business, or to rescue them. So then you have to just, if you come at the last stage, then you have to just finish it through liquidation. That's the end of the business, kind of that. So it is highly it's a subjectivity when the directors realize that they cannot able, insolvency is on the way.
Joseph?
I probably, yeah, I was going to add to that, because I think I agree with everything that just said there. I think sort of, the first thing that jumps out to me is your cash flow. But if your cash flow starts and that you're starting to get issues there, then that's where you might start to want to ask questions. What I think it's worth bearing in mind, and it can always be difficult in these situations because you're looking at your company and you're thinking, oh, this is starting to get difficult. But directors have certain responsibilities that they have, particularly under the Companies Act, in terms of acting in the best interest of the company and its creditors. So you've got that kind of added weight and pressure on your shoulders that actually, yes, I've got to try and find a way out of this if I can. But actually, I've got some responsibilities here to do the right thing for the company. I mentioned it very briefly, but touched on it in terms of sort of liquidators' responsibilities to report what the director's done. So that's really important. But I think, as Uman said, the further you get down the line, the less chance you've got of perhaps saving things. So if you think about your suppliers, if you think about your customers, perhaps think about your landlord, all of the important people that you would need on board, the quicker you could go to someone like Uman or another insolvency practitioner to get the advice on what possible options you've got for your company, you're more likely to be able to get a good outcome, because you hopefully still have those key people on board. Some obviously won't be. They'll think, well, actually, I'm going to pull the plug now. But actually, if there's a future in the business, there is some work in progress, there is some contracts that you've still got, then having those key people on board are kind of the first questions I think perhaps that Uman would be asking the director. Actually, what's the position here? Have you got this in place? And actually, the quicker you do that, I think would work really well.
But at the end of the day, there's multiple reasons why businesses end up going bust. The problem is when a company gets created by an owner or directors, it's like having a child. It's your own responsibility. You feel that you've got to help it grow and survive and become something bigger and better. But the last thing you ever want to do is to shut that down. Now, things can go wrong in multiple ways, and a pandemic perhaps is one of the reasons that nobody ever tells you about when you're in doing marketing or you're doing business planning. Where did it tell you that at university? Putting your business plans a pandemic that's going to shut the entire business of the planet down for 1.5 years virtually, if it's in your sector. So the next question then is, if you know that you should go along as soon as the alarm bells start to ring, what type of costs do you need to allocate to be able to cover liquidity?
Like I would say that generally those the director will be responsible to pay the initial cost to put the company into voluntary liquidation. You can probably the standard charge what we have seen in the industry is around 4 to 5 grand initial. Okay, that's what we have. Some insolvency practitioners charge 7 grand, some will do 10 grand. It is highly depends on the complexity of the case. It depends on how many creditors you have. But let's say if you have, it will be easier to deal with 5 creditors compared to 500. So those are the lot of complexity involved. Lot of time you have to deal with landlord. Landlord's issue will be very, very key things to deal with. Very involved solicitors you have to deal with. You have to deal with them in a different way. So it is highly depends on what kind of complexity you are dealing with, and the cost and for the insolvency practitioners will be depends on both sides. But there are 2 ways. One is pre-liquidation cost, one is post-liquidation cost. But the director is responsible just for pre-liquidation. The post-liquidation, they are not, need to pay for the post-liquidation. They are not entitled to pay. So that the answer to your question, we are roughly looking around 4 to 5 grand roughly on a industry standards approximately.
Okay. Joseph, any other comments to that?
Yes, I'm just going to add. Sorry, I was just typing an answer to Neeru, I think, in the Q&A. I put what the official receivers fees are in the answer to the question. I think this is something that it is quite different to Umen, because we're not there to provide advice to directors in terms of will only be involved in a liquidation once it goes down the compulsory liquidation route. Now there are different ways in which that can happen, but most ways are through a petition to the court. So it's a sort of active enforcement action against the company, and that's why we've just got a standard set of fees that we apply on each case, which I put in the Q&A. So it's probably a bit more relevant for Uman, I would say, than us, and we're not in the commercial aspect in that respect.
So pardon me if this is a really stupid question, but sometimes stupid questions need to be asked.
Of course, no, I think all the questions need to be answered, whatever degree they are.
If you've got debts, for example, of, I don't know, £10,000, mm-hmm. and you go to the people who you owe the money to, and you say, look, I've got £3,000. Mm-hmm. I can pay you 30 pence in the pound, mm-hmm. and clear my debts. Mm-hmm. That then clears all of the debts of the company. The costs then in closing the company down afterwards, presumably, is negligible, as you don't have any debt. Mm-hmm. Is it better spent money going that way, or coming to yourselves and saying, here's my £5,000, I can't pay off a percentage of my debt, it won't be accepted, so can you be the balancing act between what I've got and the people, and give me some protection?
I think there are two to three ways to see this question. Number one, whether the creditors who he's gonna go to say that this accepted. Now, a lot of time what we have seen, it is not a binding contract. Number one, that the customer says, all right, that's fine, they can take that 1 grand, and then they can ask for the remaining debt. So you're gonna go back, you pay 3 grand, and you go back to the same square one, that you have to pay the remaining 7. So that way, those are the things that you have to be a little bit careful. And number two, why would the creditors will accept, in this current time when everyone need money, because they have to pay their own people, and they have already expend those expenditure, basis that you're going to pay them your thing. So the trust issues will come into play, because it will be very easy for a lot of people to say, all right, but I cannot pay, I will pay you 30 pence in a pound or something, but whether the creditor is going to agree is one big thing. And also, when there is a voluntary liquidation happen, the whole process will be done by independent person to look to see that how he has done in the past, what was his action was taken. So those are the lot of positive trust being given by the creditors to make sure that independent review be possible. Otherwise, when they took the 50 grand loan, he took 47, he left with 3 grand. Now then he said that to other creditors that accept 3 grand between all you. But when the liquidation happened and they made a recovery, then all the 3 creditors will get far more. So those are the points that
very interesting, very interesting. Anything to add to that, Joe?
Again, I agree with everything Uman said there, and I think the important takeaway for me is that if you're making a proposal to your creditors, a voluntary proposal, which is I think was your initial question, Alan.
Yes.
If you're that director, you want some reassurance that actually that proposal is going to be the end, and that actually it's binding. So, whilst we've talked about voluntary liquidation, I very briefly mentioned administrations, but you'll see in the where my slide where I gave the latest stats that actually a company voluntary arrangement is another option for companies that are in difficulty. And again, that's something that Uman might want to talk a bit more about, because the insolvency service doesn't deal with a CVA as it's known, because what's happened there is essentially you're making that proposal to creditors. You're saying, I can offer you this is all we've got, and you will then end up with a dividend of say 30-40p in the pound. But if creditors accept that, and that's supervised by an insolvency practitioner, then that's binding. So it doesn't mean then further down the line that the creditor can come back and chase you for sort of the remaining amount, so to speak. So it doesn't always have to end in a liquidation if you've got a tangible and attractive proposal, I would say, to creditors. Is that a fair summary of sort of how a CVA might sort of come across to you, Uman?
CVA, I think it was very, very generous before, but since last December 2020, the preferential element comes in place, where you have to pay HMRC in full, and then whatever the balance left out need to be distributed between unsecured creditors. Now, what we have seen that generally the business have 100 grand or 200 grand of debt to HMRC, and the proportion, if you pay them in full, there won't be anything left out for the unsecured creditors. So the government policy to put the, before they were treating everyone same, but now the HMRCs, they put it a preferential treatment to HMRC. That would be a very, very damaging for the rescue procedure, because in the event, if they don't going to get anything, then, the proportion for them to accept the proposal would be very much similar to zero, kind of that. So unfortunately, but because of the government, have decided to progress in this way, the rescue procedure and R3, our regulated body, they are fighting hard for the treatment of preferential treatment, because that would hamper a lot of CVAs. But we have to just accept right now what the government policies are. They still gone through despite huge criticism.
It's interesting that you talked a bit about the business interruption loans, the BIBLs, and that those were taken out by companies without any guarantees. Mm-hmm. Yet there are some strings still attached for making sure that the loans were actually used by the business itself, and that there is some liability within the directors of those companies to ensure that the loans that were given where no guarantees were required are still, there's still some liability, if not on a financial basis, but on a corporate basis for even establishing another company again in the future, presumably. Which I think a lot of people are very unaware of, and is something that quite a few people need to be flagged up about. I understand that some of the major UK banks have now got huge debt, looking at bad debt because of Bibbles, and there's an awful lot of action that's being talked about, being delivered by Treasury via banks to those companies. Can you sort of lead into any of what you understand is happening on that front?
Yeah, sure. What we understand that the government has given the guarantees that in the event that it will be default, we will pay it. Okay, so all the banks have paid their money from their pocket right now. Okay, until those loans either be repaid or been given default. Okay, been accepted by the banks, kind of that. If the company will be subject to an insolvency, then those money will be paid by the government. Now the issue will be like lot more. Now they majority of the people, what they have, even the government have accepted that half of this loan will be bad debt, kind of that, because it won't be recoverable. And right now, what we have seen, that there are a lot of companies who are genuinely took the loan, they wanted to repay, but the circumstances is outside their control. Now, even though the string of no guarantee is attached, by the government into the bounce back loan or any other loans, there are some, the insolvency practitioners have to check, and review, and they have a duty to investigate the affairs of the company. At that time, they will find out how the directors' conduct have done, like, the affairs of the company, what decisions they have taken, what actions they have taken. And, in a pre-liquidation time, no one able to tell you, until they have investigate, impartially, at that time, and they will report, all the outcome of their investigation to government, that how the particular company have been dealt with. So right now it's hard to say about what, there is no one brush which we can paint it in all the cases, kind of that. It is highly depends on case by case basis.
Okay. So my last question, I guess, and then you can jump in with some, Sally. It is, when you're running a business, at the end of the day, your customers are the blood flow of your business. They're the people who pay your bills. And the last thing you want to do is to upset them too much. Otherwise, you don't get any more business. And you don't want to threaten them too much, because you'll perhaps never get any business again in that way. So you have to have a sort of a bit of a balance.
Yeah.
But at the end of the day, you need paying.
Yeah.
So at what point do you think, when you are looking at these debts, that you should get somebody who can chase those debts a lot harder than what you can yourself? Because cash is king at the end of the day, and most businesses fail. And I would imagine you see more cases of poor cash flow in a business as the reason why they're going into insolvency than anything else.
Yeah, I think, you like the credits given by the businesses, they already agreed with the customer that you have to pay in next 30 days or 60 days or anything. So if the customer couldn't able to pay, then they have to provide relevant reasons that why they haven't, if the debt is subject to dispute or something like that, or anything, why they are not paying. And even if the customer is given opportunity after opportunity and they cannot able to pay, then the owner has to take some sort of action. They can appoint debt collector, they can appoint county court judgment, they can appoint a solicitor to guide them, etc., etc. However, all this thing comes with a huge cost, and as you mentioned, that the working relationship with the customer will go in a out of air completely. So that's something we have. The business person has to take care and find a balance. They have to give relevant opportunity. However, also, when you have to make a choice whether you have to pay your employees and yourself, just putting the bread to your family compared to the relationship, a lot of time it happens that you will be in a dilemma to choose putting the bread to your family first compared to others. So for the businesses, if they have to only give the credits to what they can absorb, not overstretch themselves. And another issue is that you can also give is to consider like factoring companies as well, when the debt, when you don't have, so the factoring company always give 90% in advance, and then after 30 days, the factoring the customer will pay directly to factoring company. So those are the things that the business owner has to consider if it is in a longer terms. If the business if you are blue chip customers, then generally you take it. But I would not suggest for a small businesses to include the factoring company because they charge a lot as well. So you
the problem that I've always found with factoring companies is that if you're a trading company, you don't actually make something, so your margins are actually quite low.
Yeah.
By the time you put your 10% cost in for the factor, or 5% if you're lucky, you're losing about 50% of your profits.
That's true.
Or more. Sally, were you going to ask something?
I'm just going to say, amongst many of my roles, I also am the debt chaser, and it's quite interesting. We don't often have to threaten people with county court, but occasionally we do. But we try to keep it nice and friendly because we're a service organisation. I'm the one that does the chasing because they know me, Sally Smith, and it's with some chamber members, it's the I speak to them every year to remind them of their outstanding invoice, and then we have a catch up. So it's interesting how it sort of works. There are some questions.
Who does the legal paperwork?
Oh, well, that's you, Alan. And it's interesting. As soon as the form is sent off to them, then they pay. It's only happened in 20 years. It's happened about 3 times, which I don't think is a bad track record, because people quite like what we do, which is lovely.
So in short, if I can just finish off on that, what we've found is Sally does try to do the nice bit and get harder. Let's face it, who can be tough with Sally? She's lovely.
Oh, thank you.
But we then sort of draft up a small claims court and put together all of the documentation that we present to the small claims court and say, this is the documentation trail that we've got. This is about to be sent off unless you pay by this date and time. And then when people get to see what they're confronted with and what they could end up with facing in court, suddenly it's a bit more of a stark choice to make. And so far, I've got some wood around here somewhere, but we've made the right choices. But that's because the arguments that they have in their mind about paying are very different to the arguments that they can see on a documented set of papers, which are indisputable, that are going to end up in court somewhere. How much of a small claims court ruling is actually binding and people actually get their money back from?
What we have seen that if you go with a county court, you get a lot of options. Okay, once you get the judgment, initially you can enforce, you can send bailiff, option. You can also wind up the opposite company as well on the basis of your judgment. Okay, if they don't act, when you send a claim form, okay, there is very a time started ticking, on that side. And also the business, lot of businesses have to think themselves that whether it is better to pay 3 grand or 5 grand compared to lose completely, those are the stark choices that they have to make their judgment to pay it very, very quickly this is the last resort what we are talking about. Over here, when you chase the debt, you just remember you have to pay a lot to solicitors and everything, and those costs are not claimable. So those are the expenses for you. But this is on other side, when they defend their things, they have to pay it as well. So
Yeah.
the cost was on both sides, and it's just like who backed down is something, how reasonable you wanted to be with that particular person, and you generally a settlement, I would suggest it would be a better option for everyone.
And on that note, one of the things, sorry, Sally, go on, you were going to say.
Well, sorry, no, you finish off, Alan. There's just one last question in the Q&A.
Okay, so to finish off the point that we're talking about, we as a chamber are offering a mediation and arbitration service, as some of the larger chambers of commerce do, but we're offering to do it for small local companies at a cost that's proportionate to the debt. And we're using local solicitors and business people that can get involved and work on trying to mediate a problem, a commercial dispute, so that you can end up getting debts settled quicker rather than waiting for 2 years to end up getting into court, having solicitors' costs on your side, solicitors' costs on the other side, plus barrister costs, plus court costs, all added on to a 2-year wait, can end up with being putting the business on hold for a number of years before it's resolved, and the cost can be enormous. So we're trying to offer something that is helpful to business in that way. Sorry, Sally, over to you.
No, thank you. Right, one last question. As a supplier, where do you get notice of a company or a client it's going into liquidation or insolvency, to ensure that you can actually submit a claim against them? Now, I'm thinking that I remember one of our clients actually went into insolvency, and we received a letter. So yes, Umang, where do you find out?
Generally, it will be in London Gazette, where you can find out that whether a particular person is subject, as a particular company subject to an insolvency. Is London Gazette is one of the thing. You can also do company search, where you can find that in London Gazette, the good thing is about that you have to lot of time if you use a virtual meeting option, then they have to put it Gazette that the meeting is after 1 week or 2 weeks time. So you get a lot notice, and a lot of people will check it, that if you want to find out, the London Gazette is the quickest option. But if the insolvency already happened, okay, then also you can check London Gazette, and Companies House as well, where you can get, because they have to inform in a public domain that this company is particular subject to insolvency, and their details about the insolvency practitioners will be there in Companies House as well, where you can contact them. Phone number will be there, email address will be there, and all these things will be similarly available in London Gazette as well. And then that if the company, if there is a creditor, then particular insolvency practitioners, generally the director, if they have included them, then a notification will be sent it to the particular creditor as well by law.
And then just on the compulsory liquidation side, it's very similar. Obviously, we've got the Gazette, but if there's you can access information on a winding up petition, again, which will be public. So you've got information if that action is being taken against the company. Once the company's gone into liquidation, then the official receiver, within 12 weeks, will issue a report to creditors, summarising what's happened in the liquidation, what the assets and liabilities position is, and that will go to all known creditors. And creditors will be invited to make their claim on that basis. And also, creditors will always be invited to provide any information or information they've got concerning the company, and that's perhaps relevant for UMAN as well, if there's a creditors committee, for example, in a case.
Brilliant. Thank you very much, one and all. We're now on the top of the hour, well, just a minute past. I would like to thank both Joe and Umang for being with us today. Really useful and far-ranging discussion. It is on our YouTube channel, so if you want to catch up with it later, you're able to. So thank you very much indeed. Very much look forward to seeing you both again, and yeah, keep safe. Alan,
I think that's the biggest thing to stress, that we might not have had that many people on the attending today, but liquidation of your company is one of those things that sometimes you don't want to know you're talking and listening to people about. So you'll find that there'll be a lot more people who'll listen to this and watch this on the YouTube channel. Thank you very, very much today for both of you, Mang and Joe. Thank you.
Thank you very much. Thank you very much.
Thank you, and thank you for inviting me.
Yeah.
Take care, everyone.
Yeah, I'm happy to take any questions by email or as well, or our website. We're happy to help anyone free of charge as well.
In the coming
and you've got my details as well.
In the coming days and months, that might be more than you realise.
Well, I hope not. Yeah. Okay, thank you very much, everybody.
Perfect.
Thank you.
Thanks, everyone. Cheers.
Thank you very much. Bye-bye.